Welcome to AMSA's webinar titled Temporary Residence to Permanent Residence Pathways for Migrant Workers. My name is Bahar Taheri, project consultant with AMSA, and I'll be facilitating today's webinar. Also making sure that everything runs smoothly in this webinar are AMSA team members Khan Araslan, Misrak Yakub, and Lucy Sherlock. So thank you to the AMSA team for your support. As a provincial umbrella association, AMSA acknowledges that BC is on the unceded homelands of First Nations who have stewarded this land since time immemorial. We recognize the privilege that we have as settlers on this land and acknowledge that AMSA's operations is on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations. We would like to say thank you to the Government of Canada's Temporary Foreign Worker Program for funding this event today. This project is funded by the Government of Canada's Temporary Foreign Worker Program. So without further ado, I'd like to introduce our first speaker, James McNamee. James is joining us from IRCC, and welcome, James.
Hello. As you know, I'm here to speak a little bit about our pathways for temporary to permanent residence for foreign workers and others, students included and others. So as was mentioned earlier, I am the Senior Director in the Immigration Branch that is responsible for the policy program work on many of the programs that enable folks to transition from temporary to permanent residence. But I am not, of course, responsible for all of them. So I will be covering most of them here. And if you have some specific questions with respect to some of them, I may turn to some of my colleagues at IRCC who are on the line to answer those more specific questions. This is the overview of my presentation. I'll talk a little bit about permanent and temporary economic immigration, some of the work permit programs for temporary foreign workers, the types of work permits, the pathways that exist at the federal level, and then pathways that exist at the regional level, and then provide you with some information sources at the back of the presentation. So here you can see we essentially divide, and you probably already know all of this, but I'll go over very quickly. Generally speaking, we have temporary migration and permanent economic immigration to Canada. The objective of temporary migration programs is to meet and feed and immediate labor market needs. These programs are generally not capped. They have no quotas. And any number of work permits may be requested to fill the shortages and needs of the year. These programs tend to address specific labor market needs and are intended to benefit Canada by meeting gaps that exist at any given time. On the right side, we have the permanent economic immigration, which is designed to contribute to Canada's long-term economic goals and growth. These pathways are generally part of our multi-year levels plan, which is tabled in Parliament every year to indicate the number of permanent residents that will be meeting, that will be brought in any given year, including economic immigrants. These pathways respond to both labor market needs and, more importantly, contribute and supply Canada's labor market with persons who have attributes, experience, language proficiency, education, and other factors that over time have shown to respond or to support positive economic and social outcomes in time in Canada. Went a little bit over the objectives, but just to recap, if we look at the temporary worker programs and work permits specifically, on the left side, we have programs that respond to specific needs and are managed by a combination of IRCC and ESDC, in the sense that we provide and process the work permits, and ESDC provides the labor market impact assessment. The key here is that employers need to demonstrate that there are no or very few Canadians who are able to meet this need, and therefore there's a need to bring people from overseas to fill these needs. And these tend to be employer specific. The International Mobility Program, on the other hand, is designed to meet Canada's broad economic, social, and cultural interests. There are many subtypes of IMP-like programs. There is no labor market test, and essentially, folks need to demonstrate that they're filling a specific need or providing a distinct advantage to Canada. So these may be sometimes employer specific, or as has become more frequent or more common in recent years, they tend to be open so that workers can work in any sector for a period of time. And both of these types of programs, permits are, of course, renewable with some limitations, but generally speaking, can be extended and often are. These are the distinctions between the types of work permits. Employer specific are specifically issued under the FWP program, and these require a job offer from the employer, an employment contract, and of course, labor market impact assessment. Open work permits, on the other hand, may be issued almost automatically in the case of international students who have graduated and are now eligible for a post-grad work permit. They can get these at the end by demonstrating that they met that criteria. We also issue these to the spouses or common law partners of persons who are in our inventory or in the process of being approved for permanent residence. And then we also have the open work permit for vulnerable workers. And this is a type of open work permit that specifically targets workers that have experienced challenges with their time in Canada and can access these to be able to remain here. And so the details are below on these work permits. As I noted, I am not an expert on them, but essentially this work permit was created some time ago to deal with workers who encounter abuse or at risk in workplaces in Canada. Of course, we hope that that's never the case, but when it does happen, this is an option available. And it is meant to help workers transition from a bad situation into a better one, and in the understanding, in the assumption that they want to remain in Canada. These are typically issued for about a year, but the duration can vary depending on the situation. Generally speaking, these cannot be extended because the hope is that they enable a transition to a better situation. Of course, in order to apply, workers must have had a valid employer-specific work permit before. So they must have been able to work and had the permit to do so ahead of time, and must also demonstrate the situation of abuse or risk that they are facing. And there's a broad range of what these issues could include: abuse, exploitation, harassment, mistreatment, and so on and so forth. The abuse may not necessarily always involve the employer. It can be in relation to a coworker or recruiter, a third party. And in assessing these, IRCC will not contact the alleged the victimizer in this case, or advise that this is going on, recognizing that we don't want to exacerbate any vulnerability that's out there already. Once approved, the worker can look for a new job and become eligible to work in the new area under this work permit. If not accepted, the current work permit will not change. So someone who applies for this doesn't necessarily lose the current status that they're in. So that is, again, another way in which we try to mitigate for the harm that might arise from exposing or discussing these situations. Switching now to the next slide, permanent immigration, which is actually more my area of expertise. We have, as probably many of you know, some well-established programs for transition or for access to permanent residence. Our oldest and sort of longest standing program is the Federal Skilled Worker Program. It targets higher skilled immigrants, those who have quite an advanced level of French and English competency, who have work experience at the NOC, O, A, or B, and relatively high level of education. We also have a federal skills trades program, which is designed to target those who are looking to work and be engaged in the trade sector. The conditions, the requirements are a little more flexible, but they look to the ability to actually be employed in a trade occupation. So either having sufficient experience or having the ability to work through a licensure in one of those skilled trades. The Canadian Experience Class is the other large federal program, which was originally designed to facilitate transitions of international students and workers who were already in Canada. It goes back to 2008, and while it has similar requirements as the Federal Skilled Worker Program, it does count the experience in Canada as one of the main elements. And this program has one that has grown quite significantly as Canada transitions more and more temporary workers into permanent residence. This has become sort of the marquee program for that transition. Just note that we have a bar called Express Entry, and just to clarify that the ability to apply to these programs is subject to receiving an invitation to apply through the Express Entry system. So the application management of these programs is carried out through the Express Entry system, which has its own sort of ranking and classification structure, the comprehensive ranking system. We tend to run invitation rounds for these programs on a biweekly basis. There was a time when these were paused for a bit of time because of the situation with COVID and the fact that we had a large inventory of people still awaiting decisions, but those invitations have now resumed, and we're hoping to be back on track, issuing those on a fairly frequent basis. Then we have two pilots that address long-standing, in some cases, needs. One is with respect to the home child care provider, home support worker pilots. So they're caregiver pilots that have effectively replaced the various caregiver programs that existed in the past. I would say that the main driver for these programs is to actually address the vulnerabilities that existed under the previous programs. So under these pilots, workers coming through are assessed for permanent residence in advance of receiving their work permits and coming to Canada. And they and their families are assessed and are essentially approved for permanent residence under one modality, with the exception of the final decision, which comes with the accumulation of 2 years of work experience in 3 years as a caregiver in one of the occupations that are part of the pilots. This program is relatively new, and it has been somewhat impacted by the situation with COVID and the work post-pandemic to overcome that. But we're trying to make progress in advancing these applications faster and to be able to issue those decisions more efficiently. The agri-food pilot is similar in the sense that it dates to not very long ago, and the idea behind these pilots is to actually identify workers who are working in the agricultural sector in jobs that are not seasonal, that are full-time, but yet that are currently filled by persons on temporary work permits. The idea being that this job and this need is permanent and therefore could be filled by permanent residents. And so it is a pathway for those who accumulate that experience and so on. Again, these two pilots are in the early stages of implementation. We haven't seen that many admissions through them, but there's something that we're going to continue to work to advance. We also, of course, have regional and provincial programs. On the provincial nominee program, again, these are programs for which selection decision, the ability to nominate a a candidate is devolved to the provincial and territorial governments that are part of the program, all with the exception of Quebec and Nunavut. Quebec, again, has its own structure, and Nunavut has not signed an agreement. And what these do basically is enable provinces to identify who they need and invite them through a nomination to become permanent residents. And the requirements are simply to have the ability to economically establish, have the skills, education, work experience to contribute, and an intention to reside in that province. More recently, the Atlantic Immigration Program, or used to be the pilot, now the program, as of I think early this year, it seeks to identify workers who intend to reside in Atlantic Canada, and it is to compensate in a way for the fact that the vast majority of immigrants are still settling in the large metropolitan centers and in a couple of or three provinces, Ontario, BC, and Alberta. So again, the conditions, requirements for these programs are varied. They cover all skill levels and continue to be a program that's growing and will no doubt continue to expand over the coming years. Then we have the Rural Northern Immigration Pilot, which again is a relatively new program. It's looking to transition folks to areas and communities in Canada that don't receive a lot of immigrants. So these 11 communities have been identified, and the requirements are fairly straightforward: full-time, non-seasonal job offer, work experience, high school diploma or equivalent, and minimum level of language skills, CLB4. But they rely on the interest of those communities to support those immigrants. So here we have resources for you, links to many of the pathways I described, and information about how to access those. I would sort of close off by mentioning very quickly the temporary to resident pathway that we introduced in 2021. That was in effect from May to November, and over the course of that period of time, over 91,000 applications were received from temporary workers or student graduates who were in Canada and who we wanted to retain at the time when it was very difficult to access immigrants from overseas. To date, a good number of those applications have been processed. We have, at this point, not a lot of information about those applicants other than to say that they were spread across the country, and they have been, relatively successful in gaining permanent residence fairly quickly. I believe over 40,000 persons have received permanent residence through those pilots in the span of time from May of last year. So in under a year, it's been quite successful. We'll continue to advance these pathways over the coming months, ideally with the hope of completing all of those applications by the end of next year, 2023. Wonderful. I think I'll leave it at that. I didn't want to take too much time, but happy to pause at that point. Thank you very much.
Sure. Thank you, James. Our next speakers are Will Tao and Candy Hoy from Heron Law Offices. And I will pass it over to you to share your presentation.
All right. Thank you all for attending again. And James, very good to speak with you and present with you again. It's been a pleasure. We'd like to thank AMSA for the invitation. There are 79 slides. We are not going to go through 79 slides, else we're going to be here for 3 hours, which ironically was the length of time the original Pathways to PR presentation I did many years back for AMSA was. So for that, we're going to kind of condense and summarize, but we wanted to give you and leave you with a longer PowerPoint presentation so that you have resources to bring forward to your team and to yourself after. I'd like to begin by affirming my presence on the traditional unceded territories of the Coast Salish peoples, the Squamish, the Tsleil-Waututh, and Musqueam nations.
And I acknowledge that I live and work on Treaty 4 with the presence of Treaty 6. They are the territories of the Nahiawak, the Anishinaabe, Dakota, Lakota, Nakota, and the homeland of the Métis Nation. As workers in the immigration field, we continuously unpack and reflect on the fact that these lands were never given up. They were land that was taken, and in the work that we do, we continuously learn, unlearn, unpack, and reflect on what we do on a daily basis.
Today's presentation will be in 6 parts. Again, the 6th is the Q&A, so I think we're going to do a joint one. But we wanted to give a few pain points for the current PR pathways. In presenting this presentation today, we talked to several stakeholders, settlement agency workers, migrant workers themselves, to come up with some of their critiques of the current system. So as James has provided this kind of backdrop, we're going to take it a step further with a little bit of a critique and pain points that applicants receive. Candy will then talk about BCPMP and other provincial nomination programs. As the economic streams are limited and sometimes express entry can limit your clients, it's important to understand how provincial nominations work. We're then going to pivot to talk about safety net mechanisms. These are the type of mechanisms you need when the traditional PR pathways aren't working, when you have an applicant here who may be out of status or who has stayed for many, many years but can't access PR pathways. We're going to have a brief commentary from Candy then on spouses and family members. We know during the pandemic, it's been increasingly difficult for them to reunite, and this is a big driving force behind a lot of the policy challenges that we're seeing in the space. Finally, we want to make this practical and useful for you. And I know many of you are settlement workers, some of you aren't. So hopefully this will hit you in some way, but we're going to try and give some advice and some tips for settlement workers to bring back to your own organizations and your own training. There will be a handout to follow, and all these slides will be made available for the attendees. We're working on a 3-pager after the presentation so that you have some takeaway resources as well. Importantly for framing, we're talking about low-skilled migrant workers, but we acknowledge this is a socially constructed barrier, and COVID has further blurred the lines of that. And we want to recognize the precarious lives and realities, and we will do so many times during this presentation. And finally, as all law firms have to do, we have to do a quick disclaimer that this is not legal advice. This is just information only, and we can't talk about individual cases. Sorry for a bit of a long framing, but we do want to talk about why we decided this critical feedback process, because we do think that, beyond the high level information on what these programs are and the information on the website, as workers and as those assisting migrant workers, you need to know what their concerns are, maybe why they are or are not bringing them to your table. So we kind of want to talk about that throughout our presentation. All right, moving to part 1. So we're going to talk about pain points and processes in applicant and stakeholders' perspective. So it's important to frame the challenges migrant workers, especially the quote unquote, and again, we hate this word, lower skilled NOC C and D migrant workers have, because of the limitations on the traditional express entry streams. So Canadian Experience Class, Federal Skilled Worker, and Federal Skilled Trades all exclude NOC C and D jobs. And that includes your agricultural workers, your cleaners, your care aides, and various other folks. And currently, even for those who are qualified, for example, if they're in a supervisory position, the express entry draw scores are very, very high right now, meaning that unless you have advanced degrees, you're at the ideal age, it's becoming very difficult. And oftentimes those who are qualified from the sectors that we work in are having challenges being invited to apply. So the reality is also that there's a switch and there's a sort of transition to jobs that are straddling the ineligible and eligible positions. We're switching to a tier system for, and this is called training, education, experience, and responsibilities. You're going to probably be asked about this because position duties and titles are shifting. But a lot of applicants are stuck between a position that may be considered partially low skilled and partially skilled based on duties, and applicants have difficulty figuring out if they fit or not. Also, contractor work. It's on the rise, of course, due to the economic challenges many employers are having, but contractor work does not count for Canadian experience and does not give those additional points that are very critical for selection. And finally, the relationship, and often unequal relationship between employees and their employers, often make it so that employees are dependent on employers to support with reference letters and possibly even further steps, but those supports may not come through. So as a best practice, it's good to know the program guides, know the materials, and be prepared. James talked a bit about the agri-foods pilot. It's exciting. We've had, some folks tell us great things, that this is finally an easy to understand program. We're on the right track here. But the reality is too, there are education language requirements, including a high school diploma and CLB 4+, and a lot of the migrant workers are explaining that this is a difficult standard to achieve, especially without a high school education from their home countries. The job has to also be non-seasonal, which is in the agricultural industry, because of the seasons we have in Canada for growing, that can be very difficult, and as well the wage requirements. Of course, it's all dependent on first obtaining an employer-specific temporary work permit in Canada, which can be very difficult in many markets to obtain. So open work permits, for example, can't give you the necessary work experience for the stream. In terms of our best practices for this, just remember that workers need the employer support. They can't navigate this on their own. A lot of applications are being returned for things such as illegibility, that they can't read what was being written because the access to computer issue. Also, in general, there have been fewer precedents, especially on the BC side. We spoke to some colleagues in Ontario where this seems to be very well known, but it seems like even with some of these programs regionally, more education can be done in different parts of Canada to ensure that those folks who are applying know what the programs are about and the workers themselves have access. There's no real-time counter of accepted number of applications. So a lot of issues with application timing and applications being sent back because there is a cap for this particular program. And as well, the settlement funds have become an issue. So do know this is expiring May 2023. I hope the government renews it because we've heard positive feedback from, finally a category just for agri-foods. But just note that this is something that I think more collective education is needed for. I won't talk too much about the rural northern immigration pilot and also the pending municipal nomination program, because these are relatively new. A lot of the stakeholders we talk to are saying, they're interested, but they're just trying to learn more about it. So I think, again, more stakeholder work in this area, and asking if you're a settlement organization for IRCC to make presentations on this, maybe just on this program, if you're part of those 11 communities or in neighboring communities. But it's very much driven by municipalities, employers, and chambers of commerce. So we do want to flag that when things are, given to third parties, and this seems to be an intentional shift towards having more autonomy from cities, from employers, from sort of local on the ground, it also opens up the risk of fraud and companies perhaps taking advantage of their sort of being able to be a gatekeeper. So it's always good to canvass that with your clients and make sure to refer them if you feel like there's any challenges. The municipal nomination program is not in place yet. It's on the government mandate, and I'm sure they'll speak to it in the Q&A if it's asked, but it's been delayed. But again, it's an exciting program that gives the municipalities and cities more power to select the immigrants in their community. So yeah, I won't go too, I'll kind of skip this one, but more workshops and training are needed. And I think employers in general have been skeptical about applicants' long-term intention to move towards those communities. So something to flag. With respect to the caregiver programs, again, these are two pilots and two programs that I think the applicants are very excited about on the face and in instruction. The idea of becoming a permanent resident or being approved before you actually step foot here or even have to do the work is a positive step. This, if those who argue for status on arrival, it's a move towards that direction. On the flip side, though, this program, probably because it's been so new and it's so revolutionary in the way that it's being processed, has created some significant delays. Many applicants haven't had their applications decided. They've lost the job offers that were underlining them. There's been clashes between the paper-based applications and the other electronic-based extensions that they've been working on. For example, a visitor extension or a work permit extension not connected to this program. The two systems seem to not always align, at least for our clients, they haven't. And then there's a requirement for the one-year diploma that seems prohibitive, especially for many caregivers that are more on the family-based or come from cultures or communities where getting additional education isn't a requirement to do the important work of caregiving. So again, we're not clear as to how many PRs have landed through this program, but it's a question that I think a lot of stakeholders have. Pitfalls include, again, past refusals, misrepresentations. The applications will get scrutinized for marital status issues, delays, especially for the countries that largely source this program. Go to workshops. The Migrant Worker Center have amazing workshops. Get your documents together early and make sure the work history and work and employment is properly listed, because there could be clashes. All right, so we're about the 10-minute mark, so I'm going to move forward onto this commentary on the TR to PR pathway. This has given a lot of applicants hope, and I think, you can view it from different perspectives, but the fact that there was something that needed to be done mid-COVID to appreciate and to understand the challenges that migrant workers were going through and give them a support, a much needed support, I think was a good thing. And it didn't need employer support, which is, again, a shift in direction, and for many workers very much needed. But the reality was it was just open for a short duration. It was a one-time thing. And then the instructions weren't as clear before the program was released. Actually, I think the program delivery instructions came after the program was released. So a lot of folks had difficulty navigating that. And if you think about a migrant worker with even less access to resources, it made things a little bit not a little bit, much more challenging. They had to be employed at the time of the application, which made it challenging for those who had lost status. The language tests, again, were an issue. And then there were technological barriers that hindered many workers in the process as well, especially accessing the portals that needed to be used for the submission. So I'm not going to read this stakeholder feedback, but for those who sort of want to know what an example of some feedback is, and maybe for our government friends, this is a good reading to show the kind of case issue that might come to your door, or someone who's representing 27 migrant workers, only 7 were able to get to the program because of the need for the language tests and the document requirements. All right, so Candy, I'm going to pass it over to you to talk a bit about the alternative PR streams, and I'll advance your slides.
Yeah, so from the poll, we know that a lot of you guys are from BC, so I'm going to go through a little bit more detail of what the BC program is. And the one that we're going to go into a bit more detail on is called the entry level and semi-skilled. So really it's for high demand foreign workers. You create a profile, and it's free to create. And then you're scored and entered into a selection pool. So similarly to the EE one, and then it's also maximum, your registration is only good for about 12 months at a time. They invite the highest scoring people. You have 30 days to submit the application. Then there is, once you do the application, there is a fee. There's a $700 fee to that. So when we think about the advantages of a PNP over a federal program, is that age is usually irrelevant. The level of education may be less demanding, especially when we compare it to express entry, and the language skills also vary. And usually on a relatively basis, it is less demanding than federal programs such as the express entry. But PNP programs do entail a bit, double the processing time and double the fees, because there is a fee for the provincial side and also the federal side. And then the next slide, please. Low skilled options. So the ELSF that we're talking about, there are specific NOCs, Cs, and Ds occupations for all of BC, but if you live in the purple area that we've highlighted, there is any NOC, C, and D occupations are eligible if you live in that certain area, which I believe some of you guys do live in that area that I saw in the poll. So if you here we've done a screenshot of all the eligible positions for the rest of the province. The ones that I'm going to highlight is probably going to be about the occupations in healthcare. We've talked a lot about agriculture and things like that, but this one, PNPs do look into the NOC, C, and D for healthcare, and in particularly, we're talking about nursing aides that we had talked about earlier. Next slide, please. But unfortunately, this does entail a job offer. So the employer is involved. Has to be a non-season full-time employment located in BC. And then it has to require the employee to spend the majority of the time in BC. If it is a majority outside of BC, it does not qualify, even if the company is located in BC. And again, if you're a contractor, you don't qualify, unfortunately. And then so you also want to refer to the NOC, Work BC industry standards to determine the minimum qualifications for an occupation. So for example, with long haul drivers, we know that there is a specific they must have a valid BC Class 1 driver's license for a duration of the work, air brake endorsement, and then other certification as well. So need to be very specific in that area. Again, we talk about the employer because it is dependent on them. They have to be permanently in BC for at least the past 2 years, but they can be incorporated, provincially registered, limited liability partnership, and it can also be a nonprofit employer. So it doesn't have to be for a profit employer. But mainly has to be they have to be operating BC for the last 2 years. For the Greater Vancouver Regional District, they have to have at least 5 indeterminate full-time employees or full-time equivalent, but in the rest of outside of the Greater Vancouver area, they need 3 of those employees. And when we say employees, there are people that need to be on the payroll of the company. So they have to have the T4s and everything associated with it. Next, please. Next, we talk about the eligibility, so the applicant themselves. So we talk about it has to be a 9 month of full-time with the same employer. So it needs to be consecutive. And then also the education, again, it has to do with high school or high school equivalent to Canadian. And then the CLB, the language score is 4. And then annual vacation, you can have that within the consecutive 9 months, but it can't be a very long period of time. It has to be reasonable when being assessed for the 9 months. Next is the meeting that there's an income requirement and it's based on family size. So I took a screenshot of what is required. And then again, it is Metro Vancouver and outside Vancouver. And then again, we talk about you have to tell the PNP that there's any changes, and the employers actually signs that they have to inform them if there's any change in your job or job offer. And then there's certain times when you are not eligible at all. Again, I talked about that once you create that profile, you'll be scored and put into a selection pool. This is how you are scored. Details can be found in the BCPNP guideline. Next, we're going to be talking about the most recent invitation. So I took screenshots of the invitation that actually occurred yesterday on the 23rd. So you can see that once you have a score of above at least 80 or actually even 75, as you can see for the ELSS program that we're talking about, you will get an invitation to apply. The score on August 16th was actually 78. So it was actually higher than this last one. But then on August 10th, it's 76. So it kind of fluctuates in the higher to mid 70 marks. So if you have 80, you're pretty much guaranteed. But if you're kind of mid 70, you may need to find that perfect timing of the pool. Also, there sometimes is targeted draws. So you can see on August 16th, there was a targeted healthcare draw for NOC 3413, which is the nurse aides that we're talking about before. There wasn't one this time, but there was one on the August 10th draw as well. And the score was again at the 60 mark for the nurse aide specific draw. So best practice and common pitfalls. So those are the things that we have found happen in our practice. Next slide is the document checklist. And then I really just want to talk about the main common requirements we see in majority of the PNP programs. So if you meet these criteria, you can probably find a PNP program that will fit your needs. So if you have a CLB 4 or above, a high school education and or above, a full-time, permanent, indeterminate, non-seasonal job offer is required. And then like, often the wage is median or prevailing, and how you can find that is based on your own region, own province. And then the critical thing is to be genuine. The next part is the work experience. Usually they require 6 to 12 months of work experience. Some provinces is a cumulative, some of them is consecutive, but location has to be, and it also depends on your intended province. Some note is that some provinces have listed approved employers, so not all employers can give you the job offer or even give you the work experience. So an example would be Saskatchewan, and then some provinces have specifics about work experience or job offer if the applicant is a graduate of Canada or even a graduate of the intended province. They will have a bit of a different set of criteria for them. I also want to point out the slides remaining are going to all be the different provinces, but because we've talked so heavily about agriculture workers, I want to again focus a bit on the healthcare side if we have any of those people in our audience today. So there are Alberta, Manitoba, Ontario, Nova Scotia, and Saskatchewan all have the NOC 3413, which is the nurse aides, orderlies, and patient service associates with the PNP associated with it. I also wanted to highlight that Saskatchewan has actually been doing a lot of pilots lately, so keep an eye on that. I know that there was a hard to fill pilot that just began last December, and you know that is the one that includes the nurse aides that we talked about, or I just mentioned. Lastly, we're going to talk very briefly about the Atlantic Immigration Nomination Program. As James has said, it's because of most people wanting to settle in the metropolitan centers. This is why the program came to be, but you have to have at least a NOC C or above. So not all skill levels, it has to be NOC C or above when you apply. And then you have a proof of funds unless you are already living and working in Canada with a valid work permit. And then back to Will.
Sorry for the pace, guys. We probably Kenny probably sounded like she was going through that thing a little bit fast. Again, we wanted to make sure the resource slides were available. And I think the one lesson, if Candy would agree with me from PMP, is just not to really, these things change all the time. So what we post today, tomorrow, the program can change very drastically. But number two, it's to do your due diligence and research, because sometimes because we're so focused on our one province or the one job the client currently holds or their work experience, we forget Canada as a bigger whole in areas of Canada that are actively seeking to find experienced skilled workers with Canadian work experience, or maybe they have a friend or a family member in a province. Like, these are all things in some provinces that can support potentially nominations depending on what province. So definitely take your time and look into these programs. I'm going to talk just briefly about safety net mechanisms, because these are important, especially for settlement workers, because, and like our firm too, quite oftentimes when we get approached, it's when things have already gone a little bit haywire or sideways, and the client is facing either loss of job, loss of status, concerns with ability to stay in Canada, and what they can access. So what's really important to note is there's a difference between the International Mobility Program and the Temporary Foreign Worker Program, but at the same time, both programs require employer support. So for the International Mobility Program, it's a $230 fee, and it subjects the employer to compliance review. Very few exemptions for visa required countries, and very few NOC CD position foreign workers will be able to benefit from these type of programs. The Temporary Foreign Worker Program, which is where you get your labor market impact assessments that James was lecturing about, and that creates the opportunities for many workers to come, often in large numbers. That has a $1,000 application processing fee per worker, generally speaking, and that has to be paid by the employer. And it subjects the employer to a lot of compliance inspections and advertisements and so forth. So, as a settlement worker, it's really important to be aware of the high level of fraud in this area. And a lot of foreign workers will be asked to pay for their own jobs through paying a consulting firm or paying a recruitment agency. And this is one of the largest and most prevalent forms of fraud and misrepresentation. And unfortunately, in the system, the worker often bears the brunt and will be removed before any punishment really gets levied on employers. It's also important for those, because we specifically talked about agricultural farm workers as a focus of today's presentation, to understand why there's such a challenge. And I'm sure you've seen the news recently, be it the human rights case or be it the open letter penned by the applicants, Jamaican applicants from the SWAP program. Canada's foundation for the agricultural worker program was a temporary one to cover labor shortages, and it wasn't developed as an immigration program. So, I mean, whether you want to use the wording of the workers as something where they're essentially put in a very vulnerable position, engaging in cycles of circular migration for 10 years and tied to an employer. And if the employer is not happy with them, or if things are done, often that leads to what's called repatriation, the return of the worker back to their home country. Their family members almost never get to join them. Those permits are not built in, and it creates an entire power imbalance. So these workers in general, if you want to simplify it, weren't brought into Canada to pathway them to permanent residence. And even the agri-foods worker, because of the requirements for non-seasonal, clash with this seasonal agricultural worker program. So oftentimes in our offices, we have to submit what are called humanitarian compassionate grounds applications. And these are for folks who have been in Canada for a long time or are well established, or they may be stateless. There's some other circumstance where they cannot meet a requirement of the Act and they have to apply or they want to stay in Canada. Remember, if they apply inside Canada, the officer must consider the circumstance of the applicant for humanitarian compassionate ground. So that's why the approval rates for inside Canada are much higher than an applicant outside of Canada trying to claim for H&C, where it becomes a may, where it's up to the officer's discretion whether or not to grant. And what they look at is humanitarian and compassionate considerations. And a big focus of that is the best interest of any affected children into account. So especially for your migrant worker clients who've been in Canada for many years, have children who may be Canadian citizens, this might be your pathway that you need to explore with them, or at least get them the right advice to seek representation for. It is an exceptional measure. It's a last resort. So if the H&C gets refused very commonly afterwards, it is removal or leaving Canada. There have to be compelling factors. Just the inconvenience of returning home is not enough. For migrant farm workers, it becomes a little bit difficult, as I'll show on the next slide, because most of their family might not be here because the immigration system doesn't facilitate their entry. But they do consider the situation of workers who have faced exploitation and abuse. I do want to throw a flag, though. During COVID, the approval rates dipped significantly for these applications, which is interesting because when you think of COVID, it was a situation that created a lot of humanitarian compassion, but the approval rates simultaneously fell during that period. It's a two-stage process. After first stage approval, if they're approved, and usually comes about 1.5 years and sometimes longer, the applicant can then get a work permit or study permit to stay in Canada and to use. And then, generally there's no interview for this. It's all based on a written application. So it's really on the strength of a really good affidavits, narratives, letters of support, photos, proof of the community involvement, those type of things. And we've put the link to the application forms and the intake and who might apply. These are the general characteristics considered by the officer, the factors: the establishment of Canada, ties to Canada, length of time, training and education, volunteer work, community support, best interest of the child. The factors in the home country do factor in. So if there's hardship or conditions in the home country that lead to the foreign national to needing to stay in Canada, that's always an important factor. Family violence is triaged very well right now, I would say, to give to the department's credit. They are pulling cases where there are family violence. So if you do have a client who is not only out of status or in Canada with precarious status, but they're also facing family violence from their spouse or from someone else in their family in Canada or internationally, this is something that you want to flag. And then the application is assessed holistically, and it is discretionary. I won't go too much into the best interest of the child, although this is the most important concept in Canadian immigration. I'd say one of them. But know that they're not looking at hardship as the lens for children. They're looking at what is in that child's best interest. And the decision maker has to identify that and assess factors such as the emotional, social, cultural well-being of the child with respect to their age, their medical needs, education, and gender. For migrant workers specifically, it's becoming more and more of their PR option because, let's say, they can't fit agri-foods for whatever reason. They're in this seasonal agricultural worker program, for example. They have no other viable PR options. Express entry doesn't fit for them. And again, if they've experienced abuse, exploitation in their recruitment or employment, that might be a factor that needs to be driven out in their particular applications. For establishment, you have the support letters from friends and family, the work details, community involvement, English classes are becoming important to show on this. And then, of course, what happens if they have to return to their country of citizenship. A case sample, agency for migrant workers. I just put an example of Mary, a citizen of Philippines, and kind of a fact scenario that might show up on your door, and should she apply for an agency application. But this is the type of scenario that if you work in the settlement space, you will see a lot of. Unfortunately, with agencies, there's not as much community support. Like a lot of it's not covered by legal aid. There are very few clinics that do it. It's a huge need. I wish there was funders. I would be the first one to volunteer to set up a agency clinic. But unfortunately, right now, it's a lot of, practitioners who are doing this out of their goodwill, or some legal clinics who are able to make exceptions taking these type of cases on. A little information about how to do, assist a worker. I'm not going to go through this particular slide, but for best practices, know the common issues, know what happens that even an agency doesn't give them status. They can still be removed waiting for stage approval. The kind of fear of enforcement, removal, and identity and status issues that will be created when you have to make an agency application is all important to know. And fees and stuff are on this page. For interest of time, I'm just going to briefly talk about TRPs. This is the temporary sort of counterbalance to agencies. If someone doesn't meet a requirement of the act or is otherwise inadmissible, they can apply for a temporary resident permit. And this you'll see often where a worker might have a misrepresentation issue or a criminality issue, or they've lost status in Canada, but they're outside the 90-day restoration period. These are the type of applications they submit. It's a balance between Canada's social, humanitarian, economic commitments, and is also the commitment to health and security and the individual's purpose. So it's a compelling reasons is the new test that the courts like to use. It's and instructions. What is the risks of allowing this individual to stay versus the reasons, compelling reasons why they want to stay? And economic reasons tend to be very high in that process. It is $200. It has to be a paper-based application, and it does also require significant supporting evidence, such as affidavits and support letters. I just put a Q&A here for common questions, can't be online. You can add it to applications at a procedural fairness stage. And it is hard for a migrant worker with family ties outside Canada to try and show that there's compelling need to stay, but it can be done at the same time. And I have critiques about this program. I think that, there needs to be more assessment. I think when it was initially built, it was for sort of the more serious criminality and human rights violation cases. Hopefully the government will put some more resources into expanding what TRP means for migrant farm workers, for example, who aren't able to stay in Canada for status issues. I'm not going to go over this because James went over it quite well in his slide, the vulnerable open work permit. But just to know it's been hit or miss again for victims of sexual abuse at the hands of their employer. We've heard very, very good, really, well put together processes to support them and give them work permits right away. But at the same time, they're still having problems with the way that some of these applications are being triaged. And I guess our big concern from the applicant side is some of this involves a migrant worker acknowledging their own wrongdoing or their own mistakes. And we have heard cases where it was used to enforce the removal of them on, misrepresentation or other grounds. And we hope that there is a little bit more clarity to ensure that that kind of stuff doesn't happen on a regular basis.
So we know that IRCC is being utilizing more processing tools to filter temporary applications, right? So the tools that we're talking about include like Chinook, AI, so artificial intelligence systems, so things that to kind of aid the new up and coming technology world that we live in on a daily basis. There seems to be on average a higher refusal rate from global south. So the visa requiring countries, and mainly the reasons we see is the lack of family ties in the country of residence or citizenship, the purpose of visit, finances or the source of the finance is sometimes in question when you do like an officer's note access to information. Challenges of making a dual intent argument as well, right? If you have a spousal sponsorship in place and then you're also coming in as a temporary foreign or a temporary visitor. So that's an argument that's been difficult to make sometimes. Next slide 2, bridging open work permit, but if it is only eligible, you're only eligible for a bridging open work permit. So in the case where you have already applied for a provincial nomination program, you're waiting for your PR approval, you can do a bridging open work permit, but it is only for people that originally held a work permit. So you can't go from a visitor status or a student status to a working permit. Support for spouses and dependents. Only the caregiver program that was discussed in more detail by James explicitly talks about supporting not only the caregiver that is going to be the worker, but also they talk about how to come with your spouse or your common law partner, as well as your dependent children. So that's the only program that explicitly states it. The other programs seem to imply that you just have to include them in your PR application and then they get approved with you when your application is approved. So in other sense, they must have their own temporary status. And then oftentimes the NOC-CND work jobs that these the workers that we're talking about right now, their work permits in NOC-CND jobs don't allow them to have an open work permit for their spouses, unlike for skilled worker spouses. And then also remember that Canada currently doesn't have any immigration options for fiance. So like I said, only your spouse, common law partner, or what we call conjugal partner, but not necessarily your fiance. And there's also no sibling options for immigration as well. But they can be included with your parents as a dependent if they're under the age of 22. As I'm sure we're all aware, with COVID-19, the global pandemic, the lockdowns, it's been really hard for everyone's mental health and financially challenging for many people. But I think we would all agree that when you're a migrant worker or when we work with migrant workers, they seem to bear the forefront of that. And we actually talk about the link that we have there. It does talk about the crowded housing, the economic exploitation, the unsafe work environment, right? I've been recently working with an agriculture worker. His contract literally states he's supposed to work 40 to 60 hours a week with no overtime pay, expected to work more hours, all dependent on crop growth, which is very unpredictable, right? And then also the fear of them they're hesitant to speak up because of their vulnerable status in Canada, because they're afraid of any repercussions if they do speak out. And even if we recall back in June of 2020, Mexico actually had stopped sending temporary foreign workers to Canada, even though there was a giant demand because of the unsafe environment that they were being exposed to and the different quarantine measures that they were expected to abide by. So just an overall view.
All right. So leave with 5 tips. We'll do them in 4 minutes for settlement workers. And again, for those who are not settlement workers, hopefully you'll take your own takeaways from this and bring them to your own organizations. Know the on-the-ground realities: computer literacy loss, language barriers, cost of interpretation, status issues, relationships. We're working on several now, spousal sponsorships for out-of-status spouses who were former migrant workers who lost status, the social isolation, power dynamics versus the employers, how isolating that could be, family and health issues when you're working in Canada to possibly support a loved one and without your loved ones here, and then navigating conflict. Your role as a settlement worker will put you in conflicts for sure, between sort of what you're being funded or what you're being supported to do, and also the workers and what you want to do to help them. I'll talk a little bit about that in a second here. Number 2 is know the basics of misrepresentation, just because this is becoming a big low-hanging fruit. And when you talk about misrepresentation especially for things that could be honest, Canada's immigration system we have an innocent misrepresentation carve out, but it's very, very hard to meet. In general, any mistake, if it was material and it can induce an error, It doesn't have to be intentional. It can create misrepresentation. So you can think about, failure to disclose dependents, or you can think about putting your work history wrong. A lot of little things, even, to failure to disclose previous refusals to other countries. Like, there's a lot of things that can raise that. Number 3 tip is to draw lines on your do's and don'ts. Who can practice for free? No Section 91. So, even as a settlement worker, you'll get enticed by certain folks, perhaps, a little extra money here. Can you pay me to translate that? Just know your role and know, where you could be crossing the ethical boundaries. Again, refer to your own organizations for that. Gather documents. You can help them gather information, connect them with the supports in the community, and consulting community-based resources and building your own resources, right? So if you know how the system works, even if you can't give that advice, at least you know enough about it that you can direct them in the right direction and be a bit of like a project manager on their administrative challenges. That's always a good role. And we've provided also referral options in BC. For other cities, I encourage you to look into your own resources. We do know most people are coming from BC, and we know we have this list from there. Number 4 is to understand immigration at the intersections and your positionality. So, the immigration issues might not even be apparent at the face. It could come from a lack of access to social services, to benefits, to language training, to the alcohol, health, and drug issues that applicants are having. There's an increased demand now for ethical recruitment. That's going to be an industry that I know the government is very focused on ensuring that that's done right. And there's been too much especially during the pandemic, unethical recruitment. Immigration status, employment, and human rights issues. It requires compassion, understanding, patience. So these are all things that you're going to have to bring to your work. And using IRCC's own anti-racism framework, I think I love this. I could spend forever just looking at this. First of all, it's colorful, but also, just the different ways it breaks down. But look at where you stand in your positionality in this work, especially if you're white, especially if you're privileged, especially if you're, doing work for racialized communities or on behalf of them. Look at where you stand in this circle, where you stand in these various areas, and recognizing how that might impact the way that you treat your clients and the clients perceive you. Finally, know the tips in current debates. I know we're at time, but there's a huge call for status of all versus occupational and regional work permits that I think the government's working towards. Credential assessments for healthcare workers has been a big issue. I think the government, based on the mandate that the Prime Minister gave the minister, there's going to be a huge amnesty project in the fall. I don't think maybe you can ask IRCC. I'm going to ask IRCC if no one asks, what that might look like in terms of helping undocumented workers who then might come see your settlement organizations for first steps. How this affects family separation, challenges in home country of residence, knowing what that's like. Tech barriers and labor shortages. All of these are issues. And I just want to leave you with one picture. And I think Shane Martinez, counsel for migrant workers who raised a complaint against a DNA sweep of Black and brown migrant farm workers, he posted this picture, and I just thought on Twitter, and I just thought it was really, a good close. You see foreign workers sleeping on foam, looks like a foam sheet on crates in a farm, sort of during the pandemic. So, if that doesn't motivate you in your work, I don't know what will. So, thank you so much for taking time, and apologies for going a few minutes over on our end.
Thank you, Will and Candy. So much information. You're both such a wealth of information. So thank you. I'll invite James back for our Q&A session. So I'll start with a couple of questions that were already answered in the Q&A box. There was one that Candy answered. The question was, in order to apply for the caregiver pilots and agri-food pilot, does the candidate need to be on the express entry platform? And Candy responded with, no, caregiver and agri-food do not go through the EE management system. Is there anything you'd like to add to that? Or that pretty much answers it.
I would say so. No, they're not included in express entry.
Great. Next question. So this question's for James. Is there a plan to open the TR to PR portal again this year?
Maybe I'll take that one and expand a little bit. There were a number of questions about TR to PR pathways, PMM 44, and so on and so forth. I think what I can say is that there is a lot of interest in continuing to encourage and find ways to facilitate the transition from temporary residence to permanent residence. Last year's portal was a one-time, never to be repeated initiative initially. That was how it was presented. We were responding to the reality of borders being closed and ability to access immigrants from overseas. So we said we have to find a way to meet quite ambitious admissions targets as were presented in the levels plan of the day. So our response was, let's look at the in-Canada population. Let's create a very facilitative program of limited duration to respond to this need. That happened. It's in process. I can't speculate whether that will come back, whether a version of it will be returning. At this point in time, there's no indication that that's going to be the case. But that's not to say that we're not going to be continuing to find ways to facilitate and enhance the pathways that already exist, and possibly looking at creating new pathways, but probably not in the same sort of emergency response to a crisis kind of framework as was the case last year.
We have a comment and anyone can jump in to respond. The single, and I think Will and Candy touched on this in their presentation, the single most common deterrent to any immigration pathway is language proficiency. I have heard this objection almost every time I speak to migrant farm workers about immigration. Is there anything in this pathway that can minimize or eliminate this issue for migrants?
So unfortunately, with our review of almost all programs, including all the provincial nomination programs, the minimum language requirement seems to be consensus is CLB4. What sometimes we suggest is, if they can't go to any language classes due to their work schedule, listening to the news media outlets, listening in more, trying to reframe as much as possible, using mother tongue and practicing the language as best as possible whenever possible. Speaking maybe to the employer to see if you could take the time away from your busy work schedule and putting it into your schedule to go to those learning classes, asking your employer if there's that possibility for resource. But it does not seem like it is a consensus through all programs. CLB4 is a minimum requirement for language, unfortunately. Nothing that I see.
Kenny, I'll take it even a step further. I think we need to ask IRCC if they're willing to reopen and relook into this issue, because the reality is the same levels being required at this stage is the same level for citizenship, right? So why are we asking for it at the front end when it's not related necessarily to the work or like at all, right? So I think that this is for policy people, for those who are advocates, like this is an area of growth and opportunity where we can really say, why is this requirement still in place? And if you do want to keep this requirement in place, how do we facilitate to make it easier for migrant workers to, that they're not sitting in front of a computer for the first time in their life alongside, other graduates and business people with headphones on trying to do a test that's just not suited for their experience and their work, and it's not needed, right? So I think those are questions that we should be asking. And I'm glad that, and I think that, every time I have the opportunity to do so, I'm asking IRCC to think about this too. So, and there seems to be some willingness to accept this feedback.
So I can address that. I mean, I think important for us and is what Candy just mentioned, the fact that this is a uniform requirement across all programs. And just to clarify, that's intentionally the case. We lobbied and negotiated with provincial nominee programs and provinces back a decade ago to ensure that every program had a minimum language requirement. And the reason's simple. At the time, the debate was around worker safety, ability to have the flexibility to seek other employment other than the work you were doing immediately. And there is acknowledged a disconnect between how the fact that we do not assess systematically language at the temporary worker side, but then we require it for permanent residents. And I think it's probably worth noting that until recently, those pathways were pretty distinct, right? You were coming to Canada temporarily, and the expectation was that after, and until not very long ago, after 5 years, you couldn't renew anymore. You had to go back because the idea was that this was a temporary program. As time has gone by, we've evolved. We have now created numerous bridges between the two programs. And in fact, we're getting closer to a place where they're becoming sort of sequential. You temporarily transition to permanent residence. So it is something we're looking at. But I think at some point, there's going to have to be something to ensure that people who are coming to live and work and make a life in Canada have the minimum to be able to be successful, not just in the work they're doing today, but the work that they will do eventually. And there's some research that shows that upon admission, language acquisition is very difficult. People don't necessarily improve their language competency very easily with time in Canada. It's for the very reasons you mentioned. People are busy, people are doing many, many things. So we don't want to create a situation where we're exacerbating vulnerability and condemning people to a type of employment where they can't get out of it, right? So I think agree, this, ever since I've been at IRCC, this has been an issue. You know, why do you require this? And we require it, as you know, across every program, including at the high skill end, including for those who are native speakers of English or French. You can have a PhD in English from Oxford, you're still gonna have to write that test. And we see it also as an integrity measure, right? Everyone has demonstrated through something that's assessed by a third party that they have enough competency to meet whatever the level is. And the minimum level is, I believe, the ability to comprehend and communicate enough to ensure health and safety, but also an opportunity to have more flexibility and mobility in your work opportunities over your lifetime in Canada.
I just gonna say though, but it's very interesting because when I was reviewing the PNP programs for our presentation today, I note that for skilled workers in some of the provinces, they don't require the language tests, and it's just the employer to certify that they have the English level required for it. So I thought that was interesting, but for NOC C and D, they specifically say you need to have a CLB4. So I thought that was interesting. And one of the audience members also mentioned something very interesting that I think I agree with. You know, the work permits don't allow the temporary resident to study in Canada. So that it really impedes their ability to go, maybe to go to an ESL class, right? That they have in their local community. But because it's a study program, because they're on a work permit, their work permit doesn't allow them to study. It literally says on their conditions, they're not allowed to study. Perhaps that needs to be advocated that, you know, you can go to ESL classes, right? English learning classes while you're on a work permit in Canada to improve your ability and to give yourself more, less vulnerability. Like you said, right? We want to keep these people safe as much as possible, which is why you said that, like, it's important to have a certain English level, right? But if we're impeding these people in doing that to better themselves, so to speak, right? And to protect themselves, to give them more power, that's something that I think could be explored, is that condition to be removed, that you're able to go to an English ESL program class locally offered by your community center or from the college or university.
And then funding becomes an issue too, because for foreign nationals that are not a permanent residents, you know, the funding for these type of things is not that great. So there's room though. There's important policy discussion that we're having. There's a lot of questions.
That point about the ability to study while working, I think, is one that we're looking at now. And I think possibly the intent of that restriction that you're referencing, Candy, I think was in reference to degree granting studies, you know, whether you're going to do a degree, a 2, 3, 4-year degree. It doesn't prevent you, or anyone, in fact, from studying 6 months or less in a non-degree granting course, as far as I know.
That 6-month counter starts the minute you start, you've entered Canada, right? You have to do it right when you start in Canada. Whereas in the first 6 months of someone new to Canada, they're probably just trying to settle into Canada and learning the ropes of their new job, their new environment. So to have 6 months is fine, but not having that 6 months start from the day you enter Canada may be another point.
We'll take that one back because that's interesting. And good feedback. Thank you.
Sorry.
Thank you. This seems to be a important topic, especially in our chat as well. But I was just going to say, hearing James explain the background of these things is so important. And we often don't get a chance to speak to IRCC. So it's so helpful to hear, like, okay, this was the logic behind these certain things. And then, So for me, that's really helpful, I think, for everyone here. But also having a discussion around like maybe what can be changed or what needs to be changed in this evolution of the TR to PR, right? As you said, James, things were supposed to be just temporary and permanent, and there's two separate things, but now there's more of a pathway. Our next question, there was a comment that Will made where it was around ethical recruitment. And what were you referring to around that?
Okay. So again, this is I have to admit I'm not into this field yet, and it's emerging field. But the idea of a way to tackle some of the fraud that seems to be rampant in this area is to work both from a country to country level, but also with those who are in the recruitment employment section to set better standards, regulations, and rules of the game governance to ensure that process is occurring ethically and properly, especially in countries that have been identified as ones where exploitation is being noted, where workers are leaving the country but paying their whole life savings to a recruiter who then holds their lives hostage in Canada. Essentially, they're spending their time in Canada working to pay back that one individual. And all this is going behind the scenes, and it's hidden as consulting fees or some sort of fee. And I know the government's very active on this file. I've had colleagues at IRCC who I've worked with in the past who've been really studying this on a careful level. But again, I think post-pandemic, now that country movement and relationships these conversations can start again, I think it's important to focus on it.
Great, thank you. Another question is, what is the difference between the early childhood educator versus the home child care support program?
I think they're two different jobs in general. They are even under two different NOCs, so they can't be interchanging that. So it's important when assessing to find the right NOC code. A lot of times you might be given a certain title, but your duties actually fall under a different NOC. It's very important for one to review the duties under the NOC that they believe they made. Based on the duties, they may find that they fall under a different NOC. Yeah, anything to add, James and Will?
I would say yes, there are differences that are specific to the NOC, and it's important that the main duties correspond to those of the NOC you're selecting, right? Because that's what the assessment will be based on. Job titles vary, right? And some NOCs have multiple job titles, some that look sometimes even contradictory. You're doing two job titles that sound different, but they're actually in the same NOC. So it's important to reflect on what those main duties are. And I think often that's where sometimes there's challenges. If you're maybe doing something, but your title is different, focus on what you're actually the job you're performing.
Okay, great. Thank you. Another question is, based on eligibility, can someone apply for multiple streams at the same time? For example, BCPNP, as well as the Express Entry, as well as the Agri-Food Pilot Program.
Absolutely.
Go ahead. We get this question a lot, to say that we on the IRCC side impose no restriction on the number and quantity of applications clients are willing to put through. Only one will be decided, right? Whichever one is closest to the decision will be the one that you get a decision on. Positive, right? You may not qualify for one, but qualify for the other one. So the first positive one is the one that will carry through. But you have no limit. There's no regulatory or legislative limit on the number, or even on the type. You can have a family class and economic class at the same time.
I do want to flag, though, the policy implications of something like this. So, for example, during the TR to PR, you had a lot of folks who were, in the provincial nomination stream, or waiting 2-3 years for provincial nomination, trying to jump ship to the TR to PR because it was quicker. And when folks do kind of switch between different programs, it can create a bit of an administrative burden, both on the department, but also on just numbers and targeting and stuff like that. Again, I don't speak for the department. I'm just assuming, see these things in practice. So I think that, there could be clear communications also around, some people think that they have 3 applications together, that they're going to be processed faster or something. And, these things have to be sort of debunked in a more open way, I think.
Great, thank you. I know this is more for migrant workers, but we've had a couple questions around international students and if there are specific pathways to PR for international students. So if any of you would like to touch on that, that would be good.
There's a lot of PNP programs that are specifically tailored to graduates in Canada, especially to their own province. So I would encourage the person to look into the province of that they intend to reside, or if they intend to reside in their current province that they graduate from, there likely is a PNP stream for them. I can't say if it'll be faster, but there are options.
It's also important to add that during the pandemic, the Canadian experience class, the draws were much lower. So what we're seeing now is sort of the reopening expansion. Everybody wants everything to be open, and the scores have gone a bit higher because of the backlog. This is a very fluid situation. And again, I don't want to speak for the department, but it seems like once the numbers get done in the coming years, it could return to a bit of a different, if you're in Canada with Canadian work experience, it might be different than if you are, a foreign skilled worker not in Canada. There could be different guidelines and posts for the two groups. So keep your eye on the changing developments, because this year it's abnormal with the backlog and of course what's going on in Ukraine and Afghanistan and many situations.
The other thing I would add is, when Express Entry came to be, we didn't have a specific, score in mind that would result in an invitation to apply. It entirely responds to the quantity of applications profiles that are residing in Express Entry and the relative quality of those profiles, right? So as the numbers grow and you have bands of profiles at a certain, very large bands at a certain point level, it may be difficult for folks to be invited who are below that band because that band is so heavily subscribed. On our website, we publish the bands, the point bands in the Express Entry pool in real time. So you can take a look at it. And, I was just taking a look at myself, and you can see several segmentations where there are large numbers of candidates who meet those point scores. So in a normal year, I think we were, in fact, I'll go back in time and say, I think at one point in time, we hoped that candidates in the 300s would be invited quite regularly, 300 CRS points. I don't think we've ever actually gotten there because the quality has been so high and the numbers have been smaller than needed to get there. But that's how that system works at currently, right? It's based on primarily what your points are. There was the student question. Most CC candidates are student graduates. So people who have studied in Canada, graduated, accumulated the work experience through the postgrad work permit, and then became eligible for Express Entry. So indeed, a lot of students end up finding a pathway to permanent residence through the process of graduating and acquiring work experience. And we expect that to continue to be one of the main sources for skilled immigrants in the future. Is the source are the student graduates, the people that are being trained and educated in Canada, and then acquire the work experience necessary to transition over to permanent residence.
Great, thank you. We've had this question come up a couple of times about the TR to PR transition that is available for migrant workers who are on the TRP-VTP, which comes with open work permit. After being on this TRP for 5 consecutive years, they are eligible to apply for PR. Is there anything you can speak to on that?
James, you want to take the first stab at that? Because I think it's more on the pathways to PR for TRP holders and also maybe regular economic streams if you hold a TRP.
Yeah, I think this is long-standing. If you've held a TRP beyond a certain amount of time, you become eligible for permanent residence and remaining. I think that's not something new. It's been around for a long time. I'm not an expert on TRPs, but I know that that's been in place. I don't think we've done anything in recent memory to expedite or modify that, but I don't know anything. I don't know everything. I know some things. So if there's something newer, that you folks that are practitioners can comment on, I'd be happy to
Yeah.
respond to that.
Sorry,
I think
the person that asked the question added, my question is why Canadian experience is not considered for their work experience. And is that true?
I think a lot of it, and I have to go back to the ministerial instructions and the wording, but I think a lot of it's because you have to hold temporary resident status, and when you hold a TRP, and so there's restrictions on unauthorized work, and if you don't hold, because when a lot of the work is being done based on you holding this TRP that essentially acknowledges that you're working without authorization, or you have in the past, and I think that getting on and off a TRP has been a huge issue, and I think it's something the department needs to focus on, if I'm not mistaken. But James, do you know specifically? I'm trying to go back to the TRP, to the ministerial instructions. I got to take a look at that.
Sorry, I guess we're getting really detailed here. This is in the context of the ability to count work experience that then awards either points in CRS or eligibility under one of the skilled migration programs. Is that the question? Yeah, I think, again, generally the work experience that you can accumulate that counts towards your work experience factors in any of the, maybe not any, but most of the federal economic programs has to be acquired through, non-seasonal full-time work that's authorized in Canada. So generally you have to have a permit that allows you to work. And that's why it's counted that way. That's generally how work experience is accounted and accumulated in the programs. I don't know that we make an exception for work experience acquired while being on a TRP, because I think you answered that question, Will, that it was acquired through a permit that is extraordinary in its nature, right? You're here essentially without a visa, but with an ability to stay and work and support yourself while you're here. The same is applicable, for example, to someone who's applied for asylum and is working under a work permit, but who's not authorized, who would not normally be authorized to work, or who has an unenforced removal order applied to them, right? There are many folks who fall into those categories that are working and accumulating experience. That experience does not count for the purposes of accessing transition pathways to permanent residence. Even in the context of TR to PR last year, we did not allow all work experience to count, only certain types of work experience accumulated. So that's just consistent with all the various mechanisms. And let me clarify, within the economic pathways, we have other pathways that are in the public policy side of the act that may waive, may allow, may not even require this sort of experience to be counted. But in the context of economic immigration, that part of the act, they tend to require that work experience be accumulated through to be authorized in order to be counted towards your experience or otherwise.
I think the main thing is that although they have permit and the authorization to work, they don't necessarily have temporary resident status, which they need both. They need the temporary resident status and the authorization at the same time in order for that work to count towards programs like CEC, Canadian Experience Class. I think that's I would
actually ask this to James, and it's an interesting question because of the way there's IRCC's website, and we can't always trust online websites, especially when they constantly change. But it says, as a holder valid TRP, both you and your family members are both permit holders and temporary residents. So I mean, that's getting really technical, but does it count as a temporary resident status when you hold a TRP? And if that's the only thing you'd overcome, you have to have status when you land, which is a barrier. But I think that there are ways you can better clarify whether that counts towards express entry within the context of that. So these are great questions, though. These are actually revealing the little gaps and the little nuances in the wordings that can be clarified.
So I would say that maybe that language needs to be clarified in the sense that having been on a TRP here and having accumulated that work experience does not place you in a position to be able to count that work experience towards your application for permanent residence if you were to submit one. In the same way that the experience you accumulate as a student while studying doesn't count towards your accumulated work experience towards CEC or otherwise, right? You have to have graduated, you have to have a work permit to work, in this case, a post-grad work permit, and then that experience counts. You're here on a valid status as a student, but that work experience 20 hours a week that you do during your time doesn't count towards that.
James, I think they're holding CRPs and probably a study permit and a work permit, which then kind of further complicates that because the study permit, But anyways, we have actually several clients now in that same situation. It's one that needs to be, needs some clarity for sure, because more and more people are on TRPs and it's hard to get off of one. So yeah, for sure.
Thank you. We have another question on the chat. On the topic of ethical recruitment of migrant workers, IRCC and the College of Immigration Consultants introduced a new code of immigration consultants in June 2022 that clarifies that migrant workers cannot be charged fees for labor recruitment services, and it gives you the section number, and states if immigration consulting fees are charged to any client, they must be fair and reasonable. To my knowledge, there's no public information yet on what constitutes fair and reasonable fees for immigration consulting. But this might be an important thing to follow up with IRCC and the college as an important issue for workers. I guess the question is, will IRCC or the College of Immigration Consultants introduce fair and reasonable fees list?
I don't know whether we will, but I think generally speaking, in the context of when we look at fees of this sort, the fair and reasonable should probably be defined better, but in defining it, we also don't want to paint ourselves into a corner that says, X amount is reasonable and beyond that is not, because I think it's a bit gray, right? What is fair and reasonable exactly? It's hard to define, but I think we see this in other programs too, right? Where we don't support usurious fees being charged, but we don't have a line that draws a distinction between what's reasonable and what isn't reasonable. Are fees that cover your costs without making a profit reasonable? Maybe, but maybe you need to cover you need to have a few profits to be functional if you are organization X or Y, right? So I think that's why it's worded that way. Certainly, I think we could do some more work to kind of clarify that a little bit better and not leave it so open-ended that no one knows what that means, to something a little more specific. We tend to do this through program delivery instructions and things of the sort that we make public that kind of give a sense of what the parameters are for what we're talking about. And I think this is so new that it's probably something that is arising from an instinct that we want to make sure that this isn't abused, but we have yet to come to a point where we make it clear enough that we understand the parameters, right? Between this and this is reasonable, beyond this is unreasonable.
And I think ultimately it's about protecting the migrant worker, right? So they have something to go by, that if someone's charging them way beyond that, then Candy, did you want to jump in?
Yeah, as a member of the college, I'm actually a member, I'm an RCRC, so I'm actually a member of the college that we're speaking of. So this was actually brought up, the recruiter information, at a recent seminar that my advocacy group had hosted, and we talked about this. And there's the reason perhaps they had said is that it's hard to define a certain amount of money because it is so locally driven. Because if a market is saturated, that fair and reasonable could be a very different number versus a place where there's not as a saturation. But the main thing is that this new code of ethics that was published on the Gazette, the purpose of it is to protect the clients that we have, to be as transparent as possible with regards to the fees that we're charging or the fees that we are receiving. So it is required on our service agreement now that if we are charging, let's say we're getting a fee from the employer for recruiting or for helping this person, we actually state it in the agreement, and it is actually in the code that it must be stated. So we need to, this code is mainly the main thing that was required is for the transparency of our members, or members like me, to give my client, so that my client is informed. They're not kept in the shadows. I'm not, in the back end getting more money that they didn't realize that I was getting. That was the whole purpose, not so much about the fair and reasonable, because even if you were to go and hire a consultant or a lawyer, immigration lawyer, in BC, the amount that you would charge in BC would be completely different from what I would charge in Saskatchewan, because the market is so different. So take the code as a way of ensuring that there's transparency from the members of the college like myself, but it isn't to bind us to say that this is the only amount that you can charge, because it's again ruled by the local community.
Thanks for the context of where, no, that's really helpful. That makes total sense. We had a question in the Q&A box that was actually answered by an IRCC team member, but I want to read it out. My spouse is currently living outside Canada. Can I apply an open work permit for her along with my PGWP application? And I'm assuming everyone here knows what PGWP means. There's a lot of acronyms in our webinar today. And the answer was the application for the OWP for spouses of skilled workers can be submitted at the same time as an application for a PGWP has been made. And then they included a link. So it says, please see general eligibility for spouses or common law partners of skilled workers, the C41. And then at the bottom it says, note, the applicant for a C41 work permit must provide evidence that the PGWP holder is working in a high skilled occupation. They can apply at the same time, but the C41 applicant will not be assessed until the PGWP application has been issued. Does anyone want to add anything to this?
So that's actually something that I was talking about, right? The fact that NOC-D job workers don't have that international mobility access for their spouse or their dependents. And that's something that we had flagged in our presentation, right? A skilled worker, a temporary worker is just as valuable and need the support of their family and someone in a NOC-D job. And we hope that RSCC will open up that C41 maybe to what we call non-skilled jobs. Again, that term is very, it has its connotations, unfortunately.
All I would say is that traditionally that was the case. We think because of the wages issue, right? As you're looking at NOC-D occupations, the wages folks are earning, their ability to support a family and so on and so forth is more limited. And then if you look at the traditional transition pathway that existed traditionally, it was mostly limited to those with skills at the NOC-OAB, right? So, and reminding everyone as well that, when we look at that skill levels for permanent immigration on the economic side, B used to be at the federal level as low as we would go, right? With tier coming in line, in November of this year, some of those classifications are becoming more expansive. We're including, I believe, 16 occupations that didn't used to be considered skilled enough for skilled migration to now be part of it. And that's a reflection of just the way we assess these things now, so that essentially we will consider for economic immigration on the permanent side any occupation for which some level of post-secondary education or training or capacity building is needed, not necessarily a degree granting one. So hence truck drivers will be included because they take a course that requires, I believe, high school in order to be able to take the course, and therefore becomes now eligible for, in theory, any of the federal economic programs. And in fact, eligible for invitations to apply through Express Entry too, because those occupations will now be eligible for CEC.
On that note, when you say that NOC-D skilled workers, their pay, right, is harder for them to support. But that is the exact reason why they even need more, that their spouse does have an open work permit, so then they can add to the income that the family is receiving, right? They actually need it more so than someone that is in a skilled position at a higher paying job, because their family is making more money with just that one person working versus a lower skilled job person. Having the spouse working alongside with them would allow them to have that savings so that they can have that settlement fund for programs like agri-food pilot, right? That requires the same amount of settlement fund as a skilled worker, a foreign skilled worker that isn't working in Canada. So C41 is actually, I think, even with what you've highlighted, is even more important for someone that is at a lower skilled job, making perhaps lesser pay per hour.
I want to throw an additional challenge in here beyond what just Candy said as well, is right now, because of how competitive permanent residences, the scores, the access points, there is this fear, justified or not, that spouses of workers who are here temporarily, if they bring the whole family here on the basis of family ties, that they're going to overstay, or if they don't have an option to continue to stay, there's no way for them to extract and then leave Canada at the end of their authorized stay. So we are seeing, we saw during the pandemic, and I'm going to have a report on this coming up soon, drops in approval rates especially from global South countries during the pandemic for spouses of accompanying skilled workers and students, and getting refused at a higher level, of being denied entry to Canada. So these are things that are on the radar. And I think one of the challenges is, and I don't know, is probably the word that's spoken out the most, but dual intention needs to be better and clearly, better defined. What dual intention means, who does it apply to? Do you need to show a feasible pathway to permanent residence before you drop that word? What do you need to prove? Because I think there's still a lot of confusion on the applicant side on concepts like that.
I think you're touching on one of the things that our minister has said publicly, and it is that he has asked the department to look into the issue of dual intent because of these situations that arise in its application, right? Ultimately, these decisions are made by trained decision makers who, in case anyone around doesn't know this, the standard of proof for a decision is balanced probabilities, 50 plus or minus 1. So a decision maker who is a little more convinced that everything is okay may say yes, and a decision maker who is a little less convinced that everything is okay will say no. And that's essentially the bar, right? It's not beyond reasonable doubt. It's not that stringent. So as a result, when we look at approval rates and comparisons across regions and missions, it's not very uniform. It's very specific to the decision maker, and ultimately, can that decision maker defend the decision he or she made on a particular case? That's what it comes down to, right? When we get litigated, that's the question that the courts ask. Was this a reasonable decision? Was there evidence? Was it weighed appropriately? And was a decision that's reasonable made? Your view of a reasonable decision and my view of a reasonable decision may be different. And that's, in fact, the world we live in, right? But this issue of dual intent is one I think that we're seized with, and one that our minister and our bosses are very interested in knowing and clarifying, because it does cause confusion, and it clearly that's the case. Yeah, but this is good because
and I was going to say, though, as much as we throw this objectivity on reasonableness, I mean, I think the reality is to, and we're starting to see this more as data becomes more open, and we're able to look at approval and refusal rates based on country of citizenship, based on country of residence, that there is a huge discrepancy, that if you are from Korea or Japan, you're going to be approved 98% of the time. Or if you're certain programs, you're a visa exempt study permit applicant, you're going through a fast track AI process that will approve you, versus if you're coming from a country in the global South or from Africa and your application's sitting in a pile with limited resources to review. This is the reality of processing. I think we're working to try and make it a more equitable system, and I think that there's really good people in the department who are trying as well. But this is the question for the next, I would say many years of work on these technological systems, especially, like how do we build equity into them?
Yes, thank you. So we're coming to the end of our webinar. We've had some really great discussions. James, thank you. Will, Candy, thank you for all of your knowledge, insight, and being open to questions coming at you from all directions, all different programs. I can only imagine, it's for a person listening, it's a lot of information, but thank you. Do you want to say final words, final comments that you want to leave us with?
Well, I think I'd like to just say thank you for inviting us to be part of this discussion. It's a very important one. I think we touched on many issues that are current. The reference to our sort of anti-racism strategy, for example, at IRCC and the Government of Canada is something that I think reflects what is emerging from our experience in the recent years, looking back at our work. So I think that we're at an important point in time, right? As Canada is expanding immigration, we are, very publicly telling the world that we are open for more and more immigrants, and therefore creating new and more innovative pathways. We're in a moment of expansion, and so as we grow so quickly, there will be challenges. There will be things that will be happening very quick that we'll need to kind of catch up in time. But from where we sit in the department, I think we're seeing a enormous transformation across the board, and all with the view to a place where this program can continue to help build the Canada of the future and continue in that long tradition that has been part of our fabric as a nation since we came to be in 1867. So it is a very exciting time, but there will always be things that we can improve upon. So thank you for inviting us and giving us a chance to talk a little bit about where things are going.
I echo James. I thank you, Amsa, for the invitation to Heron for us to speak. Thank you, James, presenting with us again. And thank you to the audience for your kind words and appreciation of our work. We appreciate you just as much. And thank you for bringing so much of this to our attention. Working in the field, sometimes getting different perspectives is so very important in order to be able to learn and continuously learn, and we continuously learn with you. Thank you.
Yeah, I want to echo James and Candy. Thank you so much for the invitation, Bahar. It's great to speak to everyone again. I'll leave on a really positive note. Just each one of you attending this, regardless of what your capacity is, you have the capacity to really be a difference maker in one way or the other, either helping your clients find the right resources, or even at a simple level, just flagging to either your management or to folks like us on a anonymous basis that there are things that can be improved. And it's through collaboratively sharing information, discussing it, being open with each other, acknowledging shortcomings, acknowledging our own limitations, that we really build on and improve the system. So I think that the fact that there's a lot of good people on, working to build a system, gives me a lot of hope. So thank you for being part of that.
Thank you, everyone. And I think ultimately the messaging is that we're all here doing the work, frontline workers, IRCC, lawyers, immigration consultants, hopefully everyone who's here today to help in protecting migrant workers who are such an important part of, Canadian society, putting food on our table. There's so many different things that we rely on migrant workers for. And so with that, I'll just have some closing comments. So again, a special thank you to James, Will, and Candy for giving us your time. Thank you to the AMSA team in the background, making sure everything's running smoothly, Misrat, Khan, and Lucy. As I mentioned earlier on, we will be sending out an evaluation survey after this session. Within that, we will also include the links shared by our speakers today, and in the Q&A box, there was a few links shared as well. So we will send that along with the email that we send for the evaluation survey. If you could please take 5 minutes to complete the survey, it really helps us in improving future sessions. And also we ask you about other topics that you'd like to hear about in future sessions. So it is really helpful. We meticulously do go through those. So thank you to anyone that's going to be filling that out. If you're interested in attending any of our upcoming events, or if you would like to get more information or access to a particular resource, there are a few ways to connect with us. Visit the Migrant Worker Hub website, where you can access different resources, as well as sign up for a newsletter where we share our latest resources, online and in-person events. And it's free to sign up for everyone. And you can also follow us on AMSA social media on Twitter and Facebook at AMSA BC. And on LinkedIn, you can find us under AMSA. Lastly, if you have any questions, you can email us at migrantworkerhub@amsa.org. And again, we would like to thank the Government of Canada's Temporary Foreign Worker Program for funding this event today. And thank you all for attending this webinar session on the role on temporary residents to permanent residence pathways for migrant workers. And have a great rest of your day. Thank you, everyone.